Today, the Iowa Supreme Court ruling the state auditor can use his own counsel in his case against the City of Davenport. Maddie Franz joins us in the studio now to break down the court's decision. Hey, Maddie.
Hey, Harrison. Yeah, this all started in October of 2023 with settlements paid to former city administrator Corey Spiegel and 2 other city employees who threatened to sue the city claiming harassment. Now, to avoid court, former city attorney Tom Warner signed off on a deal to give Spiegel $1.6 million, only seeking city council's approval weeks later after the November 2023 elections. Now, a few months later, State Auditor Rob Sand announced plans to audit the city. He filed subpoenas for executive sessions with City Council and Warner, where they discussed the settlements agreements. The city resisted, appealing all the way to the Iowa Supreme Court that Sand couldn't access those meetings due to attorney-client privilege. Now, here's where it gets a little messy. The Attorney General's office wrote a brief arguing that Sand had access to those meetings thanks to his authority as auditor. Now, just before the deadline, the office told Sand it would file different arguments. It said it didn't want to set a precedent giving the auditor access to privileged information. Sand took that all the way to the Supreme Court, arguing Attorney General Brenna Bird has a conflict of interest and wasn't acting in the best interest of her client, the auditor. And today, the Supreme Court sided with Sand.
In its decision issued Friday, the Iowa Supreme Court ruled Attorney General Brenna Bird does have a conflict of interest in representing State Auditor Rob Sand. She wouldn't make the arguments he wanted in court, and, quote, that is a conflict of interest, and it justifies the auditor's appearance through other counsel. The Attorney General's office told Sand why it wouldn't make his arguments. Quote, the Attorney General is responsible for defending the state's prerogatives and interests. The attorney-client privilege is vital to that. The big motivation behind viewing those executive sessions, former city attorney Tom Warner is, quote, at the center of considerable audit risk. Sand says he needs to know how the settlement payments happened and how much access the city attorney has to the city's checkbook. He claims the nearly $2 million payout was unlawfully paid in secret by the City of Davenport. Sand also wants to preserve the auditor's access to relevant privileged information. Quote, if the government can simply say attorney-client privilege and end an audit, it is the end of public transparency, accountability, and meaningful audits. In her briefing, Bird maintains she does not have a conflict of interest, and Sand didn't have the authority to use his office's general counsel. She says the court recognized her concerns about maintaining attorney-client privilege. Her statement says in part, we remain committed to our role of legally representing entities of the state of Iowa and to the checks and balances that make our government one of the people, by the people, and for the people.
Now, this isn't a final ruling from the Iowa Supreme Court. It still needs to weigh Sand's argument with the city's argument. It will then decide whether Sand has the right to review executive sessions about the settlements. Harrison?